Years ago, I did that for PBA. Many years. That's all. Eddie's Austin. And I said, you know, I'm just like, well, they said, look, what do you your name? The sheriff's all know you. And they're at my presence doing this. He's in federal prison. So they were about to get really embarrassed. Anyway.
All rise, please. First court is now in session. The Okaloosa County presiding.
So it'll work it out. So just one-on-one. It won't be easier.
Please be seated. Okay, we're here on our pretrial detentions. We'll begin with Mr. Eddie Lee Duran. Would the state announce the case?
Yes, sir. State of Florida versus Eddie Duran, Mark Alderman representing the state.
Okay. And would the defense just identify yourself?
May it please the court. Rod Smith of the law firm of Aver and Smith. Mr. Flowers.
Mike Flowers, Aker Smith, Grimsley. You represent the defendant, Mr. Duran, Your Honor.
Very good. And let's begin by asking the state what's their position regarding seeking a pretrial detention order.
Judge, under the statute as it's currently written, Mr. Duran is charged with a dangerous crime. Obviously, it is a first-degree felony, and that's why on Tuesday the state was obligated to, we shall move for pretrial detention. Given the qualifying criteria under 907-041, I do not believe I have a good faith argument to make that he meets any of the criteria for pretrial detention.
Very good. So you're not seeking pretrial detention?
No, sir. I have no evidence to present. No, sir.
Very good. You're not providing any, obviously, any evidence regarding that at this point? Sir. Very good. So the next order of business following from that is the defense's motion for a bond. So, Mr. Flowers, I believe this is your motion, or if you wish to pass it off to co-counsel, you may proceed.
May it please the court, Your Honor.
And we'll make some, are you intending to call any witnesses?
I am not. I have some people here I'm going to introduce to the court.
I'm sorry?
I have some people to introduce, but I'm not having, I've agreed that I'm not going to put anybody on the stand and have them testify.
Is the state intending to offer any witnesses?
No, sir.
Okay, so we'll allow the defense to make their arguments first and then the state, because they're bringing the motion, and you can, the state can then make their arguments.
Yes, sir. May it please the court. Your Honor, we're here really under the provisions of 903-046, as the court is aware. There are several criteria, but having done this for a long time, basically boils down to a couple of things. Number one, is there a risk of flight? Your Honor, I will give a brief background to make sure that the court is assured that that's not at all in the books. We've been aware, Your Honor, of the investigation of this matter since May the 3rd of this year. I became involved in this case, and John Whitaker, who's an associate in my office, became involved in this case before sometimes in mid to late May. We have communicated with some frequency with both the state attorney's office as well as the general counsel and various officers within the Okaloosa County Sheriff's Office to keep us updated. Trying to be as accurate as possible, about a week and a half, maybe 2 weeks ago, we received word that there was a decision day, which would be last Friday. By that I mean the state attorney's, the chief assistant notified us that they were going to be meeting with the family and that they would be announcing to us their decision that Friday morning.
And the decision being whether or not
there would be a charge. That's correct. I apologize, Your Honor.
That's all right.
And so we waited, and we've had, and by the way, during the course there's been some investigation where we didn't have to make statements that would be net detrimental, but we did participate in some of the investigation that was ongoing by the department as to even their own procedures and policies. Last Friday, we received notice, actually from the press, that it had just been released by a civil lawyer involved in another aspect of the case, that the charges were being filed. Within a few minutes, sure enough, I got a phone call, both from the general counsel and Mr. Alderman. I don't remember which order, but it was within literally a few minutes. At that time, Mr. Alderman and I had a discussion as to me turning him in. I told him I would. We agreed on the date and date and circumstances I would turn him in, which was going to be Tuesday evening. Well, I actually turned him in a little earlier yesterday Tuesday because there were things I wanted to avoid any further occurrence. So we have cooperated. We've turned him in. He's not going anywhere. Judge, I don't pre-try cases, and I certainly don't try to in the press, but you're aware that in this particular case, it's not a secret what this is about. I don't think my phone has gone a day without blowing up recently about people around the country who've called regarding this case, and mostly the press. And so we've known that this was coming. We've known what was likely to be the charge. We know what much of the evidence is. We know that we have defenses that we're going to assert, both as to qualified immunity, stand your ground as it applies to law enforcement, self-defense as it applies, and that it doesn't meet the standard for wanton, will, reckless in any circumstance. Those being the defenses we have, and I apologize, you weren't the judge the other day. I represent the Deputy Sheriff's Association, and a decision was made that we would defend this case. So we're not going anywhere. To add to that, I will touch on just a few things that I know the court is always interested in. Number one, family ties to the community. Without testimony, his wife Ashley is here. His father-in-law and his father are both here today. The family is comprised of 6 children, ages 8 through 17. They are homeschooled. The current person who's been doing the homeschooling is Mr. Duran, because she's now working full-time because, as Your Honor is aware, since May he's not been working as a deputy sheriff, and frankly hasn't been in a circumstance where he could, in good faith, go find a job of any consequence because of the pendency of what we knew was a possibility of this being charged. The family has a residence here. I would provide it to the court address if the court needs it, but I don't want to disclose it. They have been in Okaloosa County for several years. He was 12 years in the United States Army. He was under fire in Iraq, and then he has had 17 years in law enforcement, both in Oklahoma and here in Florida. Your Honor, the second factor that I think we need to talk about is, and I just want to back up for a second. I'm going to make sure that the court understands that we've been aware ever since he's been terminated that there were people on both sides of this issue, but he has remained here except for one brief vacation that I said, you can go right now because you may not be able to go again. He is necessary and needed by the family, but because he's not working, I haven't filed an affidavit to this effect, but Your Honor's savvy enough to know that he's got limited resources because he's not working, she's working, but he is offsetting that by he's the one now doing the homeschooling of the children. I think that it's important that we also point out there's ties to the community from his neighborhood, and again, just kind of raise your hand. We've had people I didn't even ask for, people have shown up in support. He's got a lot of support in the community. People know him, and he looks forward to his day in court. Your Honor, the other conditions, a couple I wanted to look at were his employment history. That's obviously known because he's been in law enforcement for the last 17 years. And his mental condition, Your Honor, this is not a case where a mental condition, in our view, is going to be, it's not going to be asserted as a defense, I can tell you, and I don't think it's probably relevant to anything that transpired. So in terms of flight, in terms of community, in terms of resource, everything suggests that a low bond should be the outcome of this case. I've been informed that the state's going to seek a large bond. As I look at this, I look at the next category, which is the weight of the evidence. Your Honor, I'm sure has, if not seen it, has heard about it. This case is one in which it's going to be a call that this court or a jury in this court is going to make as to whether or not this officer, when acting in accordance with what he believes was the appropriate enforcement of the law at a domestic violence circumstance, found himself confronted with a man who had armed himself and comes to the door and answers with a Glock in his right hand. Your Honor, the weight of the evidence is something you can consider. The weight of the defense, I think you already have been able to figure out. He obviously has, as Your Honor would know, he couldn't have been in law enforcement if he had any background issues of any prior violations of the law. And the nature, there's one I want to talk about, which is the nature of intimidation. I have instructed him, and he has strictly, even to friends and fellow deputies who've asked him about it, I've said no discussion whatsoever about this case and no contact with anybody about this case. And he has followed that diligently. The other thing I would like to discuss with the court is he is now being housed for reasons of his own safety in Escambia County. Last night I was able to call him, and they very graciously agreed to bring him over here this morning. About 10 o'clock morning your time, he was brought over. If he's not able to make a bond, and you know that his financial resources are limited, if he's not able to make a bond, then, Your Honor, he's going to be housed in Escambia County, making it more difficult for his family, separating him from his family, isolating him away, and making it even more difficult for his attorneys. But in reality, that is an additional punishment that has no place. We're not here to punish him yet, if ever, because we're really here to find out, is he a flight risk? He's not. Is he a danger to the community? I assert to you that the state's not going to suggest for a moment that he's a danger to the community. He has spent his entire life, his entire career and his military career trying to save people, help people. He's not a danger to the community. And the circumstances of the weapon and that sort of thing, of course, that had to be surrendered at the time he gave up his employment. Judge, I have a feeling that sometimes there's a tendency to want to kind of split the baby on these kinds of requests. And they're going to ask for a high bond. I don't think it's supported at all. In the end, the fact that this is a high-profile case, in the end that there's a lot of great interest in this case, that has nothing to do with your decision today. Your decision today has to be about, is he dangerous to himself or the community? Is he a flight risk? Is he going to do anything that would corrupt the legal system? None of those things are present. And I would point out, and I just for avoid reiteration, but I do want to point out that in the rule 3.131, it says the following. The judicial officer shall impose the first of the following conditions of release that will reasonably protect the community from risk of physical harm to persons, assure the presence of the person of the accused at trial, and assure the integrity of the judicial process. All of those are satisfied by the presentation I have made to the court this day. I have one further issue, Your Honor. I believe there's going to be. I'd like to allow, if you will, my local counsel, because he knows more about this circuit and some of the cases here, if I could defer to, just briefly, my co-counsel for the purposes of making that presentation.
If I may, Your Honor.
You may.
Judge, another factor that we ask, and frankly courts ask of themselves, is a consistent, fair, balanced approach for all cases that come before the court. And I know this court is well aware of that. This court may be aware of a similar circumstance with similar allegations with a similarly situated defendant in Okaloosa County, Florida. And the reason I don't
object at this point.
Can we approach Your Honor? Sir?
Sustained.
May I inquire as to the objection?
The objection is the basis of relevance and another case with
Another
different
case is
facts.
not relevant to this case. You need to focus on this case.
In this case, Your Honor, we might suggest that, I understand the objection, Your Honor. I'll honor the court's order, of course. What we would emphasize, Your Honor, that the flight risk, as my co-counsel has asserted, if that were a risk, we wouldn't be here. He wouldn't have come. He is here. There is no danger to the community, and I don't believe the state's going to argue that. So given the court's ruling on the state's objection, I would merely re-emphasize that which the court is aware of through an argument of co-counsel. Thank you, sir.
Thank you.
And, Your Honor, before I complete our presentation, and since there is a monetary bond because of the nature of this kind of claim, we will assert that we believe the bond should not be greater than $10,000 in this case. It is consistent with the ability to make it and with all of the criteria that we've outlined for you.
So you're requesting a $10,000 cash or professional bond?
That's correct, Your Honor.
Very good. Thank you. I was going to ask that question. Mr. Alderman?
Yes, sir. Judge, in considering bond in this case, the state would ask that you take into consideration the nature and the circumstances of the offense charged. I would agree with Mr. Smith in also considering the weight of the evidence. Obviously, this is a case where we all know what happened. We've all seen what happened. It's just a question of the interpretation. We've all seen that Mr. Duran killed Roger Fortson. Obviously, this is a very serious charge. It's a first-degree felony, punishable up to 30 years in state prison. On his score sheet, adding death points, he's going to be scoring probably a little over a decade as a minimum. So the state would ask that the court set a bond consistent with the severity of the offense. The state would recommend a cash or professional bond in the amount of $250,000. The state would also recommend a passive GPS and a requirement that he is not to leave the First Judicial Circuit of Florida. The state would also recommend that he not possess any weapons or firearms and that he have no contact with any of the victim's family members or any witnesses in the case. Thank you, Judge.
Would the defense just comment on any of the requirements?
If I could, Your Honor.
You may.
First of all, I would request that while we have no intention of leaving the First Judicial Circuit at this time and circumstances, we don't know how long this is going to be and what opportunities for employment may occur, we agree that he wouldn't leave until without prior approval by the court. Second of all, Your Honor, we believe that the idea of his being told to stay away from the family, we have no problem with that whatsoever. He's going to comply with that. We think the $250,000
or witnesses,
or witnesses, of course.
Okay, I assumed you did.
Yeah.
You object to that, but
Judge, we've actually scrupulously avoided people who even want to talk to us about it. So, and the last thing is the amount, and I've already.
What about the GPS? Are you opposed?
We're opposed to that. There's no need for it. It's just an additional expense. Most of his time is going to be spent at home because he's homeschooling 6 children.
Okay, I'm sorry.
That's it, Judge. I think I've responded to it. I think we've made our case. Temptation, I know, sometimes to split the baby, but that would be draconian in this case. There's nothing that suggests we're not here for the purpose of having this court make the determinations on some of the rulings and a jury making the decision in the end. We look forward to it.
Okay. First of all, thank you, both the state and the defense, for your arguments. And the court would be in agreement with both counsel that the criteria is set forth in 903.046, the criteria for the bond. And both defense counsel and the state, in different fashion, have gone through the criteria. And much of what was outlined, the court's not in disagreement. Normally, the ties to the community obviously are very important. The past criminal records in this case, which are non-existent, and the danger to the community, actually, which is a very key factor in these, all lead to a lesser charge. However, the state makes a good point also. These are very serious. This is a very serious charge. The state has brought the charge. There's been a probable cause ruling that has set forth this very serious charge, and somebody has died. Those are all very important, very serious considerations in this. So, based upon all that, the court is going to issue a $100,000 cash or professional bond with the pretrial services to be a condition of that, and the three of the conditions that were outlined are requested by the state: not to leave the First Judicial Circuit, no firearms, which an obvious one by the defendant, and no contact with witnesses or family members. That's perhaps the most important thing as far as something that would lead to immediate action by this court. At this point, I'm not going to require a GPS because I don't think there's been a reason to do that. If there's something that changes over time, that may change. And as it relates to leaving the First Judicial Circuit, I would say the same thing, that that's the order of the court. You framed it in a different way, except for leave of the court. We're not going to put that in the order. But in reality, as a practical matter, these things come up on at times. There may be an occasion where he seeks to do that, and quite frankly, the state may ultimately even agree to it. Depends on what the nature of the travel is. So, with that, the court will enter that, and the court entered previously the issue with regards to the pretrial detention. So, anything further, counsel?
No, Your Honor.
Okay, thank you very much. Counsel for the state.
Nothing further, Judge.
Thank you very much.
Thanks, sir.
Thank you, Your Honor.
Thank you very much.
Your Honor, can I briefly talk to the client?
I'll take you around. I know what
Sure. Yes, you definitely can.